Howdy. Howdy. Thank you. My name is Milan Markovich. I'm an associate professor of law at Texas A&M University School of Law, and it's my pleasure to welcome you here tonight for a fascinating program on non-lawyer investment in law firms. We have three very distinguished speakers here, so I'm going to introduce them briefly and introduce this topic briefly, and then I will let you hear from them. They're each going to speak for about 15 minutes, and we will open the floor to questions. So please think of questions while they're speaking as provocative or as polite as you possibly can make them. So I first encountered this issue of non-lawyer investment in law firms when England decided to reform its regime in 2007 with the Legal Services Act. So England now allows non-lawyers to invest in law firms, and you'll hear one of our speakers talk a little bit about that. The only state that allows non-lawyers to invest in law firms is not even actually a state, is the District of Columbia, where predominantly lobbyists are in some law firms. The idea of non-lawyer investment has been floated a few times, most recently as part of the Ethics 2020 Commission, but has not gotten very far in the United States. So to address this topic, this idea of non-lawyer investment and these alternative business structures, which are these non-lawyer owned firms, we are very lucky to have three wonderful speakers here today. And I'm going to introduce them in the order in which they will speak. First, we have James Peters, who is the Vice President of New Market Initiatives at LegalZoom. James is a graduate of the University of Michigan School of Law and has been with LegalZoom for a number of years. Next, we'll be hearing from Joshua King, who is the Vice President of Business Development and General Counsel of AVO. Josh is a graduate of the UC Hastings School of Law. And last, but certainly not least, is my wonderful colleague, Susan Fortney. She recently came back to Texas to join us at Texas A&M. Before that, she was a distinguished professor, Howard Lichtenstein Distinguished Professor at Hofstra University School of Law. And before that was an interim dean at a law school in Lubbock, Texas. So without further ado, I will turn the podium over to James. Thank you, James.
Thank you. Howdy, y'all. Howdy. So I wanted to talk today a little bit about why a U.S. company might want to subject itself to regulation and licensing as an alternative business structure in the UK. As an employee of one of the few companies that has done that, I think I've got a fairly good perspective on it. And I'm going to try to go over a little bit about how the system works in the UK for those who don't know it. I'm going to try to avoid getting into jargon that I haven't sort of identified before. So in the question period, if you got things that you're wondering about, please feel free to hit me up as much as is helpful. So why choose regulation as an ABS? One thing that I think is important to understand from the perspective of a company like LegalZoom is what is regulated in the UK as legal advice or legal services and what is not. So biggest thing, general legal advice is not a regulated activity in the UK. So if you were a forms provider, you're helping people fill out forms, maybe even answering questions like which form should I use, that kind of thing is fine from a UK perspective, as long as you're not holding yourself out to be a lawyer. The activities that are regulated are quite specific. They call them out in their legislation. They include exercising rights of audience, so being able to actually stand up and address a tribunal or a court on behalf of someone, conducting litigation, reserved instrument activities. Those are generally documents that transfer property from one person to another. Biggest is conveyancing, which is like a home move. Probate activities, notarial activities, and the administration of oaths. Those last two are kind of random and odd from a US perspective, but those are things that only somebody who's licensed to practice law can do in the UK. This is a small but copy of the license for LegalZoom Legal Services Limited. This is a law firm that we own in the UK that I worked on the licensing of over the course of last year. You'll note, if you look over there, that we are licensed to do all the things that a regular lawyer would be licensed to do in the UK. So, not that we necessarily want to partake in the administration of oaths as a business activity, but if we found it compelling, we could do that. One thing that's worth noting here too is the regulatory body, the Solicitors Regulation Authority. So the SRA is the entity that was chosen to regulate solicitors after the UK government decided lawyers were not very good at regulating themselves. So there was a big study in the early 2000s, a report, the Clementi report, and the findings were essentially that it's an anti-competitive atmosphere, it's not good for the consumer here, and we think we need to relook the way we regulate law. As a result, the SRA was one of many entities formed. Once the UK started allowing the licensing of ABS entities, there actually opened up fairly interesting a marketplace for regulators in the UK as well. So there's actually competition among regulators of law firms in the UK. You could be regulated by the SRA. You could also be regulated by a chartered accountants group if you specialize in activities that are mostly related to accountancy, but you do some legal advice there as well. You can be licensed by a legal executives group. There's a whole host of groups that are offering up the ability to be licensed. SRA does also handle the regulation of actual solicitors, so with your practicing certificate, like your bar here, that's the entity that does it. But this is where we are regulated. And the reason that we decided that we wanted to go with regulation in the UK versus just opening up a document shop where we could provide legal advice, our view, my view in particular, is that the UK at this time offers the closest thing to right regulation that I've seen out there. The UK has two big differences from the US in the way that they regulate the legal practice. Number one is that it's outcomes focused. So rather than prohibiting specific activities, the main goal of UK regulation is to say, you should be trying to achieve certain outcomes for your clients. If you're not doing those, you're going to be in trouble with us. The other is entity-based regulation. So instead of regulating each individual lawyer, you regulate the law firm itself. So when we first started looking into this opportunity, a lot of people thought, well, this sounds like a terrible idea. Companies, that are non-lawyer owned are going to be able to do whatever they want in the legal market. It's not anywhere close to the truth. We're actually much more regulated in the UK than our businesses in the US. That said, we feel that the particular style of regulation that's available in the UK fits with our mission, what we call our North Star, and that is to democratize the law. Our goal is to get quality legal services in the hands of as many individuals as we possibly can. It's difficult in the US because we can't provide the legal advice services on our own. And when we do partner with lawyers, which has been very helpful, we have to deal with a host of 50 different sets of regulations about exactly how we can interact with each other. It makes things quite complicated and much less seamless than they really could be for the one end user who's supposed to be the most important in this whole equation. So that's the client, the consumer of legal services. And that sums it up from my perspective.
Well, before I let you get off the stage,
Okay.
Do you think there will be a shift towards more U.S. firms incorporating as alternative business structures in the UK? I've heard rumors of even some large law firms, U.S.-based law firms, considering it, and I believe Cahill Gordon, a large New York firm, has already done it.
I think you'll see an increased number of firms going this direction. I don't think you're going to see any sort of like large percentage of U.S. firms doing it anytime soon. It doesn't make sense for a lot of people to go through the process and be subject to the cost and the regulations. I should note a couple of other things in the regulatory realm. You've got to have a compliance officer for legal practice in the UK. You also have to have one for finance, and they have to be vetted by the SRA and approved. You've got to have an office over there, practicing office. So it's not something that you can just throw out there and do without some real forethought and effort. That said, there's a couple of things of interest there. One is it's a useful way to have a chance of operating a firm where you can have real equity investment from people who are non-lawyers. So, if you really think it's valuable to have a chief technology officer, a chief operations officer, things like that, you actually have the opportunity to see how that works in the UK, and that's a meaningful thing. It's also a very interesting market, particularly for firms that are in the personal injury realm. So you've seen a lot of movement there and a lot of mergers and acquisitions, and I'd expect to see probably more US players dabble in that realm as well.
Thank you so much.
Thanks. So that UK stuff is just fascinating, isn't it? I mean, that's really quite different than what we have here. As Milan said, I'm Josh King. I'm general counsel for Avvo. I've been with Avvo for a little over 8 years, and if you're not familiar with Avvo, we have the web's largest online legal resource for consumers. And in the time that I've been working at Avvo, I've certainly been exposed to a lot of these types of issues that I think ultimately led to the development of this new regulatory structure that we see in the UK. And I'd like to just focus a little bit on where I see some of those issues being here in the US and pose some questions to you all to think about in terms of how this might end up playing out. Because if you think about it, there's really two fundamental, just huge differences in the way the UK is doing this. And mind you, this isn't it may be a foreign country, we may be separated by a common language, as they say, but there are an awful lot of similarities across the board between the United States and the UK. Yet you have these two fundamental differences where in the UK, non-lawyers can invest in law firms. They can have an ownership interest in law firms. And that can play itself out in a variety of different ways. But let's just leave that there for the moment, that fundamental difference. And the second one, which might even be more fundamental, is these reserved activities. There's only 7 of them. They're sort of, if you think through them, I don't know if I could put that slide back up again. I thought that was it in front of me? Here's the clicker. So you've got these 7, are they reserved activities, is that right? Okay, so rights of audience, conduct of litigation, reserved instrument activities. This is a pretty limited subset on the one hand, but on the other hand, it's also cuts to the core of, I think, what we all think of as being a lawyer, as what we do, the core functions of being a lawyer. And it doesn't include general legal advice and information, which is kind of interesting when you think about it. Here in the United States, we've got these definitions of the practice of law. And I've looked at the definition of the practice of law in probably every state by now. And it's kind of a frustrating exercise because it's a very, very nebulous and vague definition. It basically seems to cover just about anything that looks legal that the bar wants to reserve to itself. And I think ultimately that's going to be a problem. We know it's a problem now for consumers, but it's ultimately going to be a problem for the bar, the organized bar itself, in that it has grasped for too wide a field of territory in which it can operate. And if you, in terms of thinking through the rules that govern these areas, you have the definition of the unlicensed practice of law, and you have the definitions of why lawyers should not be sharing fees or allowing any form of investment in their practices. And I think that a lot of the bar regulators and the lawyers who look at these things maybe look at the rules very reflexively. And they say, well, it says you can't do this, so you can't do it. But there are greater principles at stake here. So for example, when you think about non-lawyer investment in law firms, you're fundamentally talking about, I mean, there's a good reason for that goes way back, in that you cannot interfere with the professional independence of the lawyer. I mean, the lawyer's professional independence has to be sacrosanct. That's what we owe to our clients. And we figured out a long time ago that, if you have, if you've got a doctor friend who's referring you cases, and you've given them, 20% of your fees, and they've got a kid in college, and they say, gee, it would be great if that case could just hurry up and settle, that's kind of a problem for the lawyer's professional independence. And so it's those kinds of situations are why we have these rules. But they've morphed into this thing where we just apply them mechanically, and we say, you know what, no, just across the board, no investment. When really the harm we're trying to guard against is that risk to the lawyer's professional independence. And I think if you look at the UK and what they've done through this form of right regulation, which is it's a very extensive form of regulation, and there's all sorts of safeguards in place, there are other ways to preserve that lawyerly independence, short of completely foreclosing this entire mechanism of providing service, which could be better for both lawyers and their clients alike. And I'll try to get back to that point in just a second. But secondarily, on the point of UPL, this is also one of those things where the bar has grasped very wide and said, okay, everything is within the practice of law. And again, this is an area where we have to go back and look at what the harms are. There's obviously a consumer protection benefit in making sure you've got some level of regulation of these types of activities. There may even be some consumer regulation benefit when it comes to general legal advice and information, but I think that is a much more of an open question. And also, how are you going to regulate it? Are you going to say that only people who are licensed as lawyers can do this? Because let's face it, I mean, that is the position that every bar association in the country is taking right now. And I predict that we're going to see the rubber meet the road on this pretty soon, because that position where you take this expansive grasp where every form of legal advice is included within the practice of law, that's going to get thrown out on constitutional grounds within the next 5 to 10 years. There are already a number of cases that are working their way up, not necessarily involving lawyers, but involving what we call occupational speech. So to what extent can regulators regulate what people do when it involves expressive activities? There's a case here in Texas that involves a veterinarian who's trying to provide veterinary services online. There's a case involving a psychologist who has a published column in Kentucky. There's a number of these types of things that are working their way through that are likely to establish a question that hasn't really been fully established yet, which is, to what extent, when the First Amendment bumps up against this kind of professional speech regulation, to what extent can the regulators regulate? And I think this is where the bars need to be asking themselves, why are we doing this? Are we doing this mechanically, or is there a reason? Where's the consumer harm? Where are we protecting the consumers? And they have to be ready to answer those questions and show where those parameters need to be. So finally, question back.
Got a question. Let me just stop at this point and make sure I'm on the right track with you. If we all ask ourselves the question, can we afford ourselves as a lawyer? Okay? Answer in most cases probably be no.
Right.
All right? Now, the next question is, where does commercialization clash with professionalism, which then goes to the question, in the investments that are made, who is your real client? If you are working in one of these firms that investors invested in and you're on the market or something, is it that client that has that individual need, or is it really your investors looking for the rate of return?
Well, I think I'll let Sarah get to the depth of that, but let me just take it really quickly in that those types of conflicts always exist. I mean, they exist within a solo practice where there's the conflict between the interest of the client and the solo attorney's interest in making sure that that he or she can make their mortgage payment, feed their kids. There's all these kinds of pressures happening.
Out there are situations where you say, and it could be very selfish, where somebody says, you know what, I'd really like to take this case to trial, but you know what, I got a mortgage to pay this month, and let's settle that case out. But this is on a grander scale that you're talking.
It may or may not be, and that's the second point I was going to make, is that when we talk about sharing fees with non-lawyers, that runs the gamut. I mean, I think we all sort of immediately think about non-lawyer investment in law firms, and we picture, suddenly you've got these big law firms that are being traded on the New York Stock Exchange. I actually, there may be cases like that, but I believe those are really going to be the outliers. We're really talking about situations where a small law firm could maybe bring in someone they know, like an accountant who's really, really sharp, who could help them run their business better, but who isn't interested in that kind of job as it exists today because they can't share in the upside of that business. That's something lawyers can't do today. Or a mid-sized law firm can't bring in a chief technology officer who could really take them to the next level and improve their systems because they can't give them the kind of equity ownership they would have in a technology company. There's a whole bunch of these types of situations that are out there that, again, are completely foreclosed by the fact that we have this across-the-board blanket regulation, instead of examining whether there are ways to have more sort of focused right regulation like we've seen in the UK. And so I think that can actually be very good for the lawyers, and it can be good for the clients too, because if you have entities that are out there that can start providing these services using some of the tools that are secondhand, quite frankly, to a lot of organized businesses in other industries, you could potentially open up all sorts of, let's call them legal services, but maybe they are things that are much more like providing general legal advice on how to fill out forms, how to navigate the family law system, things that a lot of consumers are still priced out of the market for because really they're having to make the choice between doing it themselves and hiring a lawyer that they can't afford.
Josh, can I give a quick statement on that?
Yeah.
So this is just a personal experience reply to that. When you go through this process in the UK, this is a big question on the minds of the regulators there, and they go to great lengths to talk to you to make sure they understand your business model and how you've built in protections for the client. Because at the end of the day, the firm is the regulated body when you get this ABS license, and if the firm is not upholding those requirements for that outcomes-focused regulation, the firm will not be in good standing with the SRO. So it's something that they take very seriously. It's particularly as a fairly new regulator, they don't want to get it wrong, if you will. And it's something that it's fairly thoroughly vetted in the application process.
And I'll speak to it too.
I will continue to listen.
And I will add that also in Australia, they were very intentional in building in these safeguards, which I'll talk about. But one of them is in the first company that went public, and then since that time, that the prospectus has to state that the highest duty is owed to the court, not the client. And so there is that recognition when the investors basically pay for the stock. They understand that they are getting a professional services firm that has this hierarchy of duties.
And let me just add 2 points there and just ask a quick question of Josh as well. My understanding, and James will correct me if I'm wrong, only 2 firms have actually gone public in the UK and Australia. That's Slater and Gordon. Public in the sense of publicly traded. They may have gotten non-lawyer investment. But the idea of firms on the big board, I think we're still probably a whiles away from that. And the other point is just, let's remember too, what do we do in terms of entity-based regulation here in the United States? Our primary mode of regulating is going after the individual lawyer. And I can tell you as someone who's an associate at a big firm, it's wonderful that the New York State Bar expected certain duties of me. But I was a pretty small cog in the machine of Sidley Austin, to the point that the vast majority of individuals at the firm did not know who I was. So, although I tried to wear flashy clothes to make up for that, and we talk about associates and partners fulfilling their duties, but they're part of an entity, and we don't talk about the entity's duties. So actually that brings me to a quick question to Josh here. Josh, how does your experience with AVO inform your views on this issue? Well, AVO obviously has a very important place in the legal market. How has your kind of experience there informed your understanding of this issue?
Yeah, well, we are in an interesting place in that we have, we've got about 10 million consumers every month are coming to our site, and they're either looking lawyers up, they're researching legal issues, they're asking questions. And the asking questions one is actually what started my interest in this years ago, because anyone can ask a question. They're all anonymous. We'd say what state it's from, but that's self-identified. And then attorneys answer those questions. And so right from the get-go when we launched that service, I had lots of questions from lawyers about how this implicates the unlicensed practice of law. But, and so I've done a ton of research on it and thought about it and how ridiculous it is that we extend this way beyond the breaking point, both of the Constitution and of what's really protecting consumers. But a lot of what we do as a business in trying to, and like LegalZoom, I mean, our motto might be a little bit different, but it's a pretty similar focus in that we are first and foremost focused on the consumer. We do a lot of good things for lawyers, but when push comes to shove, we're on the side of the consumer. And there are a lot of things that we would like to do with our background in e-commerce and the like, in terms of serving consumers and closing the access to justice gap, that we can't do because of the jerry-rigged, overly expansive way that the practice of law is currently both defined and regulated in this country.
Thank you, Josh.
Thanks.
Thank you. Good evening. Milan introduced me, Susan Fortney. I'm very pleased to be back in Texas. I have very deep roots, and I'm thrilled to be part of the Texas A&M law faculty and see some of my former law students and friends from that other law school in Lubbock, is the way he put it. And so what I tried to do for tonight, because I thought we would be in this setting where they may have had some weddings, is I thought about an organizing theme. And so my theme for tonight, sticking also with the British influence, is from this English rhyme that some of you may know is now part of a wedding tradition: something old, something new, something borrowed, and something blue. So first I want to be able to make the point here in terms of non-lawyer ownership of law firms that it's really something old in terms of this being kicked around even in our own country. Going back to 1981, the ABA's CUTAG Commission, that were the drafters of the ABA model rules, first proposed non-lawyer ownership in 1981. And they did that at the time they were rolling out the model rules. And eventually their draft of ABA Model Rule 5.4 ended up prohibiting non-lawyer ownership, but nevertheless it was remembered later in the District of Columbia. As Milan mentioned, the District of Columbia has a form of non-lawyer ownership, and they've had one since 1991. And so they're the only jurisdiction in the U.S. that allows these non-lawyer owners. And basically the idea is it was a way of attracting talent and improving client service so that there can be more one-stop shopping. It might be like the lobbyist that Milan had mentioned that now has an equity interest within the firm. And at least in DC now, there's anywhere between 25 to 35 firms that have these non-lawyer owners. And in visiting with the regulator there, they reported that there haven't been any reported problems related to the non-lawyer ownership. So I think that we should keep in mind when it comes to evaluating what we do going forward. As far as DC, as I mentioned, there's 25, 35 firms, no problems. And then the ABA has started looking at the DC rule back in the consideration of the ABA Ethics 2020 Commission. So at that time, there was a proposal that was along the lines of the DC 5.4 that was considered and rejected. And it was rejected by a vote of the commission members. And even though it was a modest proposal, their conclusion was that it wasn't, there really wasn't a case made for change. And so that was what was viewed as the predominant view with this ABA 2020 commission, which now brings us to the current commission. We now have this new ABA commission, which is called the Future of Legal Services. And that commission is indicated that they are going to study these different innovations, including alternative business structures. And when they do so, they're going to be considering some of what you've heard tonight. They're going to be considering the legislation in England and Wales that have allowed these alternative business structures, and they also will consider what has happened in Australia. And so from the standpoint of their consideration of what's gone on in other parts of the world, I think they're going to be, evaluating some of the arguments for and against non-lawyer ownership. And I thought it'd be good to at least put these on the screen. You might add your own. But I tried to be balanced here, have 4 for each side. So starting with the arguments for allowing non-lawyer ownership. You see that a view that is pretty common is that it promotes competition and innovation, expands access, improves the delivery of legal services. They also will point to the experience in District of Columbia and indicate that there haven't been problems there with non-lawyer ownership. And to me, what I find particularly compelling, doing a good deal of work involving law firms and law firm ethics and structure, is that we already have non-lawyers that are pretty involved in the financing of law firms. Those of you that are in private practice probably have a line of credit and have dealt with the lenders. And the lenders do a good, depending on the size of the loan or the line of credit, they're involved basically in the practice one way or another. They're exercising some form of control. So something to keep in mind there when we talk about non-lawyer ownership, not necessarily being something. Yes, sir?
Professor, I cannot resist. I said I'd be quiet, but I will not. Is this proceeding from the assumption that legal services is essentially, for the masses, a commodity?
I don't see that as an assumption, no.
Then why is it necessary to get this infusion of capital, investments in a law firm to, at the end, promote competition and innovation?
Well, it's an option that could be available to some providers. So I don't know if anybody else wants to speak to it in terms of
really, why?
Why? Okay, I'll give you an example. For example, Slater and Gordon, one of the firms that went public in Australia, they were able to get this non-lawyer financing, and it enabled them to acquire practices in smaller cities in Australia, towns. Some of those practices are ones where the doors would have closed because there wasn't a successor for that particular practice. It enabled them in terms of providing services more efficiently. They invested a phenomenal amount in technology, for example. So that provided them that kind of efficiency, and they were able to provide support, for example, to some of these practices in towns around the country that otherwise would have gone without lawyers. I don't know if you want to add anything in terms of either of you.
I had a thought just that goes to your question, because it's the problem is the question isn't why, the question is why not.
No, I think you have to answer the why first.
Actually,
why not?
This is regulated, and the question for any regulation is why do we have that regulation? Why the regulation has to defend itself. The regulator has to defend themselves. The regulators have to show why it's necessary to restrict investment in law firms. And there may be some very good reasons for that. There are definitely some very good reasons on the edges, and historically when you look at how it would interfere with the professional independence of lawyers. But if they can't effectively answer that question across the board, then then there's no basis for regulation in that area.
Okay, don't perceive my questions as being negative to this. This is absolutely fascinating, but I want to hold you to task.
Sure. Sure.
If I could just jump in just briefly on that, and then I'll get to one of my former students who has actually interesting expertise in this area. Think of this. So the question was, why would we need this? Why would we have to do this? Think about all the expenses that a new lawyer has starting out. Think about the expense of advertising. Okay? Think about a plaintiff's lawyer who has a really important case and maybe has the skill to really win that case. How's that lawyer going to fund that case or fund his practice? Digging into his own pockets, in some case risking bankruptcy. Okay? What if that lawyer could share the upside of his practice with someone who could help him pay for his expenses, pay for his advertising, and the like? Who are the only firms that essentially advertise in Texas? Plaintiffs' firms, right? Established plaintiffs' firms. To some extent, corporate law firms and specialized publications. But the reality is, the vast majority of attorneys can't afford to advertise. They can't afford to explain to the public the value that they can bring to their lives. So that, I think, to me, is at least an example where getting funding from other sources who could share in the upside of your practice could be very attractive. And I'm sure my colleagues on the stage here will jump in on this. But interestingly, a lot of the folks who are most interested in non-lawyer investment aren't the big law firms who are doing quite well, if you believe the American lawyer numbers. It is the solo practitioners. It is the Main Street lawyers who are having to really scrape to get by, and the only way they can grow their practices is by going into debt. So I think at least from that perspective, to me, as someone who's pretty neutral on this issue, and I've written some critical things about alternative business structures, I think there is certainly something appealing about that.
And just along those same...
Would you reveal to your client then if doctors now have to tell their patients that, oh, by the way, I'm referring you to this MRI facility and I own 35% of it, would you do the same thing to your client and say, look, I am financed by this operation and I owe them certain royalties too? Would you make that disclosure?
From the standpoint of making the disclosure, I'm not sure if it's anything different than telling them that you have a line of credit at Chase Bank, right? So I'm not sure if that's something that you currently share with your consumers. And again, I'm somewhat agnostic. Because I've gotten so far of the arguments for allowing. I haven't gotten to the arguments on the other side. So how about the arguments opposing non-lawyer ownership, some of which has been mentioned? Yes, sir.
I understand from the sole practitioner that the infusion of cash at the beginning can be helpful. But this is a slippery slope. I can envision the Walmarts of law firms coming in, and we have this monstrosity of this publicly owned and traded law firm practicing throughout the United States and driving the smaller grocery stores out of business. So I do see that there's a huge difference between obtaining a line of credit in which I'm responsible to the bank at a fixed amount of rate, this is what I have to pay them back, versus having investors who put their money in there who want me to drive those dollars. It's all about revenue. How much is your share price worth today? And then, in my opinion, that's not necessarily always in the best interest of the client. And that's what we're here for.
Do you want to speak to that, Ian?
A quick point. So,
Yeah. I'm not
on
sure if I
Walmart
can.
and grocery stores, when Walmart came out, there were not 85% of people who needed groceries not buying them. Today, you've got 85% of people who have legal needs who are not having them. There's a gap there. There's certainly something they can fill from having a more efficient, better system. Will that solve the problem? I don't think so. I've never been a promoter of that as curing that issue, but there's some room there. The other point, and I just want to keep coming back to this, is that anytime you've got human beings interacting at the intersection of sort of business and profession, counseling, you're going to have some good actors and some bad actors. It happens today in firms as they're regulated right now, fairly frequently. And it will happen at some point in time with an ABS. It hasn't yet, but certainly there will be one where there's a bad actor that comes out. The bottom line is it's against the rules in both cases, and in both cases there'll be appropriate punishment meted out. I think people have a bigger concern about non-lawyer investors thinking that they will come in and actually sort of, really, really control the case that it's in, the work that's being done. If that happens, the option is going to go away for those firms, and it might go away for all firms. So we'll see what happens when the first instance comes up. But to date, there are actually fewer issues on that end for ABSs than there are for traditional firms. Does that mean that traditional firms are bad? I don't think so. But it is a fact right now.
Right, and here I think it's interesting to keep in mind this whole two hemisphere, that we talk a great deal about the public ownership, but that's a very small number of firms. That the vast majority of these firms that have non-lawyer owners are the smaller firms that may have the brother-in-law who's the accountant in the firm who owns interests, not necessarily the passive investor who buys something that's publicly traded. But one thing that is interesting about the publicly traded company in Australia, the first one, Slater and Gordon, that I mentioned, the former regulator in New South Wales, where Sydney is, has done interviews with the different personnel at Slater and Gordon, and they haven't seen any of this parade of horribles. But just to come back to the arguments against here, non-lawyer ownership in the interest of balance, it's some of what you've suggested is this concern that law is a business, it would become more of a business, that now it's a profession, and that lawyers would be pushed to maximize profits, that it somehow would adversely affect lawyer independence. What a term that's commonly thrown around is that it's inconsistent with core values, and that somehow these non-lawyers are going to erode the ethical obligations of lawyers. And because my area is legal ethics, I've been doing this a long time, I really want to focus on the issues related to legal ethics. And I want to throw out a very provocative proposition, and the proposition is that non-lawyer ownership can make firms more ethical and less risky places for lawyers and their clients. I kind of choked on saying that because I knew that I'd get pushback from the audience. So let me say it again. Non-lawyer ownership can make firms more ethical and less risky places for lawyers and their clients. And to make this argument, I want to draw on my experience in conducting research in Australia. And again, when people hear Australia and changes in the legal profession, they will think of that first firm that went public, Slater and Gordon. But that wasn't really what was revolutionary in my mind. It wasn't Slater and Gordon going public. Rather, it was the legislation that allowed them to go public had in it particular safeguards to protect the public. And that's what I think is particularly noteworthy. And specifically, when we get to Australia, the safeguards for these incorporated firms there were actually 3 or 4, but the 2 that I have on the screen is that first, this incorporated firm has to have a person appointed, a kind of go-to person, this legal practitioner director. And in addition to that, it is the responsibility of this legal practitioner director to basically take steps to make sure that the firm implements and maintains what is called appropriate management systems. Now, the legislation didn't say really what appropriate management systems meant. And so the very, I think, progressive regulator in New South Wales took it upon himself to work with various stakeholders, including the legal malpractice carrier there, they have a captive carrier, the representatives from large firms, from small firms, and what they did was to develop a regulatory regime. And with this regulatory regime, what they first did was to identify what they considered to be some objectives of sound practice. And they're the kind of objectives that you think about, I hope, when you think about private practice. It's the idea that you would provide competent work, be effective in communicating with clients, basically disclose your fees, what they call cost disclosure. There's identification of conflicts of interest, records management, trust accounts, and the like. So they first came up with these 10 objectives of sound practice. And then what they did was to come up with a process for each firm to evaluate its own compliance with these objectives. And so what they created was this self-assessment process. And what the firms are provided is a self-assessment tool. And you take this tool and you in effect audit yourself. And that when you're auditing yourself and going through and determining what management systems you have in place and what's lacking, you would note whether you are non-compliant all the way through compliant plus. And the beauty of this is that as you're going through this audit, this self-audit, self-examination, you're learning how to improve your management practices. So that's why this process has been now termed education towards compliance, because you're learning as you're going through the process, and you hopefully are improving as you go through the process. If you indicate, let's say, that something is lacking, that you're non-compliant or partially compliant, then the regulator works with you to get in compliance. So this is where they're providing what is like law practice management assistance to lawyers. And so what this has become known as is proactive entity regulation. Proactive entity regulation in that you are working with the firms to improve their management systems, and that hopefully will translate to better client services. Well, this started in New South Wales and it spread to other states around Australia. And as it spread, it got the attention of various researchers. And the first big research study focused on complaints involving these incorporated firms. And the results of that were pretty impressive in terms of the reduction in complaints. You see on the screen that the complaints rates went down by 2/3 for those firms that went through this self-assessment process, and that the complaints rates of the incorporated firms that went through this process were 1/3 of the number of the complaints that were registered against firms that had not gone through that practice, the self-assessment process. So that was based purely on complaints rates. The researchers, after that study, recommended that there be additional work looking into really the reason why the complaints rates went down. And because I had worked with these researchers in the past and had relationships with the regulators, I conducted a subsequent study looking at the why question. Why did the complaints go down? And so I conducted, a study that combined surveys and interviews and asked a variety of questions. And what we saw was that again, asking the questions made a difference, because by asking the questions, what we see is that firms improved what they were doing. And what they did, you see 84% of them reviewed their firm policies and procedures, 71% actually revised their procedures, 46, close to half, adopted new systems, policies and procedures, and a small percentage, actually hired a consultant. The other thing that came out of this was looking at how the respondents thought that this process really impacted client service and other aspects of firm work. And clearly the most impact, the greatest impact, was on firm management, risk management. Well, that makes sense because many of these measures that were expected relate to management. And so that just gives you an idea of how they really influence different aspects of firm practice. So we got the results from the survey, but to me what was most instructive is the interviews. What we learned from talking to people that went through this self-assessment process. And what was interesting to me is that a number of them indicated that they really resisted this from the beginning. They were opposed to it at the outset, but once they went through the process, that their opinions changed, and that they indeed learned about controls by reading the self-assessment form, by getting assistance from the regulator. So they indeed were using this as a kind of educational tool. Some of them indicated that they had started the process, for example, to comply with the regulator and for risk management, but continued it for business development reasons. And what they started to do was to improve their management systems and continue to get an actual certification of their management system. So this is a new certification that is available from the International Standards Organization. And so some of the larger Sydney firms, for example, with whom I dealt, said that they were going to use that certification when it came to what they call tenders, which are the beauty contests when they're trying to get business from corporations and governments. So that was an interesting twist, is how improving the management systems really could make them, I think, viewed different, or could help them be viewed differently in the marketplace. I think just putting together, the results from the first study and my study is that I think we see that this whole regulatory regime provided a kind of incentive for lawyers to get their house in order. And I think that whether you're interested in non-lawyer ownership or not, the takeaway I hope that you have from my piece tonight is that there is a value to this kind of self-assessment, and that there are various tools that are available, which I'll come back to after I answer a question. Yes, sir.
The regulator under your model seems to be very important, the keeper of the standards. Who would you envision if this model were utilized in the United States? Who would perform the role of the regulator to do the evaluation?
So in the different jurisdictions that are now considering it, it is a number of different stakeholders, so that the standards get developed by lawyers from practice, management experts, the regulator, the insurers, so that it's a cooperative, basically, endeavor. Okay, and so then that way you don't come up with one size fit all, because you have various parties that have input in terms of the process, but that the regulator ultimately will be the one to oversee the process. But it's developed with basically bar leaders and other representatives. All right? Does that answer your question?
Yes.
Yes? Okay. All right. So the regulator be certified any differently than they're certified right now? They're.
If you're going to have a regulator come in and evaluate you,
right.
Is there a
I use the term regulator of whomever is the authority. So, for example, in Texas, our regulator is the state bar, right? And in the other jurisdictions that are looking at this, it is their equivalent of the state bar. But the one interesting thing that I want to bring home here is the term regulatory counsel as opposed to disciplinary counsel. Because one thing that we're trying to do as we look at this proactive regulation is to get away from thinking of disciplining lawyers after they already screw up. Rather, we want to work with lawyers so that they can improve what they do and avoid problems. So instead of relying on a reactive system of discipline, we're moving more to this proactive system of working with lawyers. So just from the standpoint of the instruments that are out there, I've encouraged you all to think about doing an assessment now. I'm not sure how many people have done them. And that's the point, I think, of how non-lawyer ownership can make firms more ethical, because what happened in Australia is the push for lawyers to do this was the legislation that required management systems, appropriate management systems. And so my hope is that whatever happens in other jurisdictions in Canada and different states in our country is that we consider, what that push is, what the incentives will be for lawyers to go through this kind of self-assessment. So that's where I end up with, something borrowed, something blue, that I'd like to, in terms of borrowing, see us build on this British and Australian experience. From the standpoint of blue, what am I thinking blue? It's this idea of being creative as we move forward, and that whatever we do in terms of non-lawyer ownership, my hope is that it will include these incentives for lawyers to build what I call the ethical infrastructure of firms. So I know it's late. I am not an evening person, so thank you for sticking around. And we'll open it up for more questions.
First off, we could thank Susan for her presentation.
Sure.
And so I think we have.
I can't stand.
Yeah, well, I think. Well, here.
No, I'm fine.
I think we have a few more minutes for questions if folks want to ask. Sir, at the front.
So how do some of these regulatory interactions interface with concerns about discoverability for malpractice issues, and are there any safe harbor provisions that have built into
Sure.
these things?
And so it's good you asked that, because this piece that I actually have that is on the table for those of you that are interested, that in there I discuss the issues of discoverability, and that you have to have that protection so this wouldn't be discoverable. So whatever kind of statutory protection, and you'll see that there's actually a model provision that's included in the article. And I used to do a lot of malpractice work, so that was something that came to mind. Thank you.
Yeah.
I'm curious, you talked a lot about the model, and that keeps coming up, sort of letting the IT people or the accountant be invested in the firm. But I'm wondering, is anybody working with the model where the social worker is a part of the group, or someone's a part of the group who's actually providing services to the client to make the services better? Is that being explored at all?
There's I don't know any in the realm of like the social worker type example, but one of the bigger movements this year, over the last year in the UK, has been accounting firms. So that's several of the big four now have law firms and are using that as back to the sort of one-stop shop model, so they can provide all those services to their clients.
If I could just add one quick point onto that. The origins of legal aid in this country were with social workers. The first legal aid workers were social workers. It was only when the federal government started extending funding that a condition of funding was that lawyers staff the legal aid offices and not social workers. So I would argue that we actually have a lot of experience with social workers delivering legal services. Sir.
Yeah, two comments. One, the last time I was here was for a wedding, so I presentation. Thank you. The second is I'm interested in our 25 years, it seems, of experience with the District of Columbia as a sort of laboratory, under the sort of laboratories of democracy theory. You talked about a lack of complaints, but I'm interested in if there's sort of indicia of success. You talked about arguments for non-lawyer ownership, including expanding access and increasing competition and innovation. Have we seen expanded access or increased competition in the District of Columbia in the last 25 years?
And it's interesting because Milan and I were talking about that on the car over, and that is the next study that should be conducted. That no one, to my knowledge, has really evaluated that. And there is a new task force in District of Columbia that is looking at globalization. And on Thursday, I'll be in D.C. meeting with the regulator, and I'm going to bring up this, let's find out what they're actually doing and what difference it's made, because the rest of the country is looking at you. So thank you.
My question is kind of a follow-up on his question, which is, what kind of, when you gave a few examples of practices, but what's been in either D.C. or Australia, what kinds of practices has this expanded? In other words, are you seeing an increase in prepaid legal services? Are you seeing cheaper and broader family law practices? Are you seeing increased plaintiffs' investment for toxic torts or products liability? for lawyers, firms that couldn't afford to finance those big cases. And my second question, I'm sorry to ask two, but it seems like the DC firms, which can obviously pro hoc vice into any case in the United States virtually, have you seen that be kind of backdoor to say, okay, there's a lawyer in Alabama who has a big toxic tort, he needs some financing, we'll get these DC investors in, and they'll become co-counsel, and we can invest in the case, and non-lawyers can finance it.
Yeah, and I'm not familiar with any of that kind of manipulation. Maybe it's there, I'm just not aware of it. In terms of the types of firms, for example, in Australia, the ones that have gone public are the one we've already mentioned, Slater Gordon, first started off big in asbestos, well-known brand in terms of personal injury. Then you had Shine, which is another big personal injury firm. They didn't have as much of a brand. They were out of Queensland, a smaller state in terms of population, but then they connected with Aaron Brockovich, so they also were in the PI area. You had another firm that's more corporate, and the last one does IP, big IP firm. The others are the incorporated firms, to my knowledge, were the same types of practices that many of them were doing already. But what enabled Slater and Gordon to do, as I mentioned, was to get into many, many other communities and expand more than they would have before. And it's also a little different in Australia because of their litigation financing.
And if I was to add a little legal ethics note on your question about splitting fees, keep in mind, if the case is in Alabama is going to prohibit you from sharing fees with non-lawyers, including the out-of-state non-lawyers. So you have a lot of problems. If DC were to embrace this completely, you'd have the issue of other lawyers from other states who prohibit fee splitting with non-lawyers not being able to share with those firms. So there's a lot of gymnastics for firms that are based in DC and have non-lawyer owners, lobbyists, where they have to be very careful what fees are going to those non-lawyers. That's on the other hand, sir.
What would be the effect on law schools? Because in the UK, you don't have to go to law school. It's an undergraduate degree. When I look at my UK lawyers and the lawyers that start fees at my law firm, they're much younger than the lawyers I'm hiring here in the US. So all of a sudden, why would I go to law school when LegalZoom's over there and they don't have to incur hundreds of thousands of dollars to practice? I can just go work for LegalZoom.
But you wouldn't be practicing law, you would be doing something else with ABS, right?
So you don't have to go to law school, but their undergraduate program is longer than ours, and they require apprenticeship for 2 years. So it's sort of, and actually you don't have to go to law school in California.
Do I have to do that to work for you, or LegalZoom is now the legal entity and I could just have a history degree and go work for you?
Well, you could have a history degree and work for LegalZoom, but you wouldn't be able to provide reserved activities to clients. So a fee earner who provides reserved activities does have to hold a practicing certificate.
I would think about it this way too. I mean, you've got legal advice is not a reserved activity in the UK. Anyone can do it. Yet there are thousands of lawyers in London who are paid very, very well to do nothing but provide legal advice. They're not going to court. They're not doing any of those reserved activities. But I mean, people want that counsel. I mean, you could probably do away with the entire UPL roles, and you'd still employ most of the lawyers because it would be, I mean, as long as you didn't do away with the holding yourself out as a lawyer one. A lot of people out there, particularly sophisticated clients, or anyone who is familiar with how the process works, for anything that starts to get important or complicated like that, is going to want someone with that training and experience.
I think we have time for one more question, sir.
Regarding the UK experience, you mentioned solicitors. Has this regulation and legislation at all affected the barrister?
Yeah, so traditionally in the UK, barristers and solicitors were kept quite separate, and basically a client would never have direct communication with a barrister. That's all been sort of fading away due to parallel rule changes. But the barristers, the Bar Standards Board has actually also started licensing ABS entities, so they can create theirs as well now.
Okay, well, it is my unfortunate duty to close this program tonight. Before I do, can I please thank Dean Artie and his amazing career services staff. And please look for more such events, cutting edge events from us in the future. Thank you.